Hello, this is a summary of the matters dealt with in tutorial 2. We did three main things. The first was to have a debate about the doctrine of parliamentary sovereignty. It was a debate on Robin Cook's comment from 1990 that, and I quote, "There is no more elitist, authoritarian, hierarchical claptrap than the doctrine of parliamentary sovereignty." Now, he uses some wonderful hyperbole there. What you need to do is to explain and argue what the doctrine is and what it isn't, the advantages and the disadvantages that that doctrine brings. And I have posted some handouts which you can use to further your understanding of the doctrine. Secondly, we looked at the institutions of government. What I did was to put people into working groups, collecting information and condensing it in order to give a presentation. Again, if you're working at this at home, this is exactly what you need to be doing, collecting the information together, which you can get from your manuals and the other textbooks and any other sources that you can find. And I looked in particular at the composition of Parliament, the House of Commons and the House of Lords. And don't forget that there is a third element in Parliament, that's the Queen in Parliament. Looked at the process of legislation. We looked in general at the legal system in terms of institutions. We looked at how Parliament scrutinises the executive, which is a very important function that Parliament does, and you can debate how effective it is in doing that, and the makeup of the executive itself. We then moved on to the royal prerogative. Its significance is that it is the source of the authority for what the executive does. Now, that authority can come either from statute. An Act of Parliament says the Secretary of State may, the Secretary of State shall, but that will give him the powers, the duties. Or the source of the authority is the royal prerogative. The definition of the royal prerogative, it's the residue of all those powers that once resided in the person of the king himself, but which hasn't yet been replaced by statute. And it's important that you can give some examples of the royal prerogative, and I've sent you a handout listing all the royal prerogatives as the Ministry of Justice recently saw it. We did a brief introduction to civil liberties. We looked at the traditional approach, where an Englishman is free to do anything he wants as long as it's not prohibited. And of course that was strengthened by a generally hands-off approach by government. They didn't interfere too much. We looked at specific freedoms of the person, and particularly the person in relation to the powers of the police, freedom of property, freedom of speech, and freedom of assembly. We looked at the flaws in the traditional system and how we've moved towards a new approach by adopting into the law itself, into English law itself, the European Convention on Human Rights. And finally, we looked at the first TMA. Now, in general, read the question and the advice on answering the question. That's what I have to look at when marking your essays. Occasionally you'll see a student who will answer the question they would have liked to have been asked. Well, I can't credit you for that. I have to look at your essay and measure it against what you're being asked to provide. Look at the marking band's criteria. Again, I'm acting like an auditor. I have to gather evidence for my conclusion as to which marking band is appropriate. So if you look at those marking band criteria, then you'll be better prepared to go for the marking band that you want to be in. Make sure that every proposition of law you make is backed by authority. So an assertion backed by a case, or backed by a statute, or backed by a great authority. And Dicey, some of the textbooks writers will be those such authorities. And finally, write for an intelligent but non-specialist reader. Don't try and blind with lots of legal sounding language. The aim is to communicate, not to baffle. Imagine a few years down the line, you're the solicitor, you've got to deal with a client and explain to them some quite complex ideas in a way that they can understand without giving an oversimplified view. The particular question that's in TMA 1, you need to define and explain prerogative powers. So all the material I've sent you and the points that you'll find in your manuals about the royal prerogative apply here. Consider the relationship between statute and prerogative powers and apply that. Explain how certain constitutional principles will apply. There are certain conventions that are relevant here. There's the concept of parliamentary sovereignty and of ministerial accountability. And finally, consider the effect of some key cases. The existence of the royal prerogative, what extinguishes it, and very importantly, the reviewability of the use of the royal prerogative. Well, all the best with your first tutorial, and I hope to see you soon.